All right. Hello, everyone. Welcome back to Empowered Esquire TV. As you see from the title of this video, we are discussing the state of Florida, the brother Polight. I believe his government name is Michael Nowak. I think that's the right pronunciation, right? So, what I intended on doing to kind of welcome you all into this topic is play a video by KKC, also known as King Kong Crazy, where he talks about, or rather, where he shows an NBC news clipping about Polight's arrest. However, there's Hurricane Henry, I believe is the name of this storm coming through, and he is causing some issues with my internet. And for some reason, YouTube is acting up and KKC's clip won't play. So instead, we're going to watch the clip from NBC News themselves. I always prefer to, give a shout out or a nod to the fam when I can, but unfortunately, it's not working out today. So we're going to watch it directly from NBC News. So welcome to everyone in the chat. Let's check out what NBC News had to say about Brother Polight, aka Michael Nowak's arrest, and then we will dive into the state of Florida criminal code. We will talk about what these charges mean, how much time he could be facing, and also whether or not some of those around him, i.e. Sonetter, because, let's be real, that's the main person that we think of when we think of people around Polight, right? Okay. So we'll also dive into whether or not Sonetter and others could possibly be implicated in some of these accusations. In the meantime, as I always tell you, living in the city, and it's a Sunday, so if you hear a kerfuffle outside, it is what it is, right? So let me share my screen. Hello to Crime Spotter, KKC, and The Rev. Let's see what NBC News had to say.
Speakers making headlines for the wrong reason. NBC6 reporter Kim Nguyen is live in Miami Beach tonight with more on the arrest of the man known as Brother Polight. Kim.
Yeah, well, Jawan, the suspect surrendered here at the Miami Beach Police Department earlier this week. Police charged him with sexual battery of a 14-year-old girl. We did speak with his lawyer earlier tonight, who says that these charges are false.
This is the mugshot of 37-year-old Michael Nowak Jr., also known as Brother Polight, to his more than 300,000 Instagram followers. Miami Beach police arrested Nowak this week for alleged sexual battery of a 14-year-old girl in a hotel room in February. Police say the alleged victim was the daughter of a woman he was romantically linked to. Defense attorney David Terrace says his client is innocent.
Once the evidence is produced, that he is going to be exonerated. So yeah, not guilty, nothing else.
According to the police report, Nowak, a motivational speaker and author who lives in LA, asked the woman if he could take her daughter to an after party at a club in Miami. The report states Nowak took the teen to his hotel after seeing that the club was closed. Police say the suspect gave the teen alcohol and started dancing and touching the teen inappropriately, groping her breast, inner thighs, and buttocks. It goes on to say Nowak tried to force the teen to perform oral sex on him. The teen allegedly passed out and woke up to Nowak trying to make her throw up.
These are serious allegations, but in any situation, there is always motive. There is always a lot behind the scenes that the public is not going to be able to see.
The report states that the girl's mother found her intoxicated and possibly on drugs, with severe swelling on her mouth and lips. It later states Nowak told the mother not to call police because it would ruin his career. Nowak was served with a DNA warrant in June and surrendered to police on Monday. Terrace says the police report is only an allegation.
And Nowak claims to have written more than 90 books. In an interview, he also claims to have several wives. For now, we're reporting live in Miami Beach. Kim Nguyen, NBC6 News.
So there you have it. You've just gotten a brief introduction into who Michael Nowak is, who Polight is, and what he's being accused of. So let's have a quick conversation about warrants, DNA warrants in particular, and how this process works. So there's been a lot of discussion online about different types of warrants and what a DNA warrant is, what it means, and whether or not it means that the DNA was a match, right? That's been the biggest kerfuffle, is whether or not the DNA was a match. So let me enlighten us on how this process works. So there are different stages and different burdens of proof for each stage of a criminal accusation. So initially, and this is hypothetically, right? Initially, a victim comes into a police station and says, I need to report a crime, right? In this instance, a young woman and her mother allegedly went into a Miami-Dade police station and reported this crime. Now, with this type of crime, the state says to themselves, we don't really have enough to just arrest Michael Nowak, right? But we have enough to meet the burden of proof for a DNA warrant. And if that DNA were to come back as matching, right, as a positive match, then we would have enough to actually arrest Michael Nowak. So for those of you online who have been saying the DNA had to have been a match, that is how he got arrested, you are correct. There is no way that the authorities could have arrested Michael Nowak if the DNA came back as an absolute negative, no chance that it could have been him, right? Now, does it mean that it was a 100% match? No. And quite frankly, DNA is almost never a 100% match. It's usually in the range of 95 to 99.9%, okay? So initially, the victim reports the crime. They take the report. They go to a judge with that report as probable cause for a DNA warrant. And if upon testing the DNA they've received, they get a match, then they've met that next level of burden of proof for them to complete the arrest. Get it? Got it. All right, let me say hello to everyone in the chat. Hello, let me see your transcripts. Hello, beautiful yours. That's a wonderful name. Hello, Whip Fanatic TV. And yes, peace to everyone in the chat. If you are in the building and would like a shout out, give me a little hello and I'll be sure to recognize you. I love to have that conversation while we're here. And really, this is for us all to have this moment of edification, right? For us all to learn about the law, learn about this process, and be able to have a educated dialogue about it. Hi to Michelle Jordan. Okay. Oh, no problem, Michelle. If you need to take a nap, I get it. And hi to Rose Ez. I hope I said your name correctly. So now that we understand how DNA warrants work, right, that they are granted with some level of proof, but they are used as the proof for the next stage of the prosecution, does anyone have any questions about DNA warrants, about the reporting of this type of crime, anything in that nature? Because if you don't, we are going to hop into the Florida statutes and take a look at what Polight is being charged with and what the details are of these charges. Whip Fanatic TV says, it's just sad how we no longer care for our young as we were cared for. Interesting perspective. Okay, so I don't see any questions about DNA warrants, so we are going to hop right into the state of Florida statutes, okay? So as I'm sure you heard in the video, right, there are 3 charges. Now, let me actually pull up the screenshot of Michael Nowak's arrest and his charges. Let me do that, and then we'll go into the statute. So, share screen, Miami-Dade County. All right, here we go. So here you are looking at the Miami-Dade Clerk of Courts, criminal justice system. They record online, as do all states, their state arrest, their ongoing open prosecutions, and what the posture of the case is. Now, posture of the case is legalese. It's a term we use in the legal world. And it means, well, what's going on? What stage is the case in? Is it in a beginning stage? Has it gone to trial? Has it been disposed of some other way? That's the posture of the case. So here you see all the info, right? You see his name, you see his date of birth, you see the date these charges were filed, right? You see who the judge is that is assigned to this matter, and you see the posture of the case. Now let's go down into the charges. We see total charges 3. So it appears to be 1 count of each of these charges. Okay, it doesn't appear to be multiple counts, at least not that we can see from this website. So we see there's a felony here. It's engaging in some type of, we try to beat the algorithm on this channel, but honestly, I think at this point we might be too far gone. But it's engaging in some type of inappropriate conduct with a minor, and it says the age is 14. That's a felony in the state of Florida. Then they have a battery in an inappropriate manner of someone who is the ages 12 to 17 when the defendant is 18 or older, and that is also a felony. And then we have contributing to the delinquency of a minor as the last charge, which is a misdemeanor. So, in case you're not familiar with criminal prosecutions, the main difference in terms of punishment for felonies and misdemeanors is that usually your misdemeanors carry a term of a year imprisonment or less, and your felonies carry a term of a year imprisonment or more, right? Typically more than a year is when you're getting into the realm of felony prosecution and imprisonment. So keep in mind these charges, because we're going to hop into the state of Florida Criminal Code and take a look at each of these charges, okay? So I'll stop sharing for a moment just to hop back in the chat. I don't see any, oh, I see some questions. Hold on. So Mara Charisse, hi, how are you, by the way? Mara Charisse says, were we cared for, or did most just never talk about it? Oh, you know, we have to remember that we're in the age of information, right? We're in the age of social media. And I think Mara has a good point. I think a lot of these things that we are discussing now and having these discussions anew about are things that really have been happening already. But because there was no social media, no Instagram, no Twitter, you know, no iPhone that people could record everything on, I think it just wasn't being discussed as much. Mara, very good point. Okay. KKC says, as a responsible adult, your name should never be in any conversation or scenario where alcohol, DNA, teens, and hotels is involved. Another interesting point. Morrow says the delinquency of a minor was giving a minor drug/alcohol, possibly correct. We will get to that, Mara. And Crime Spotter wants to know, could there be a settlement where the victim doesn't take the stand so as not to relive what happened, where he'd say, I was never convicted? Interesting. So there are some different ways that this could be disposed of, to answer Crime Spotter's question. Now, it is possible that Michael Nowak will take some sort of plea to a lesser charge. If you are familiar with Kwame Brown, you know all about lesser charges by now, right? Because he goes in on Charlemagne the God and lesser charges in these types of cases. So more than likely, the prosecution will have some type of offer on the table. Michael Nowak could plead to a lesser charge, and that would kind of ensure that the victim doesn't have to relive this. And quite frankly, very often that does happen, because prosecutors who prosecute these types of crimes are usually specifically assigned to these types of crimes. And they are very sensitive to young victims and the psychological trauma it does to have to relive. For those of you who have never worked with these types of victims before, I'm a former prosecutor. I worked with, DV victims, including families that have been abused and things like that, right? And it is very, very difficult for these victims to relive what happened to them. In fact, a lot of them suffer from PTSD that is only further compounded by, having to testify. So yes, Crime Spotter, it is very likely that the prosecution will say, will you plead to this lesser charge? And then my Vic doesn't have to relive this. But of course, that will be up to whether or not he's willing to admit some level of culpability, because he still has to admit some level of culpability. Then Jason Stevens wants to know, what sort of evidence could have been used in a DNA warrant? So what would happen, as I said, hypothetically, is that the victim would report the crime. So she would go into the police station and she would make a report that says, well, the police would make the report, but she would report to them, you know, he did the allegations that we heard in the news channel. He invited me to a hotel. He took me there. I think that I might have been drugged because I passed out. I felt that I was violated. And all of this would be reduced to writing. And that report would be brought to a judge by a prosecutor, in which the prosecutor would say, Your Honor, I am applying for a DNA warrant. In my application for this warrant, I have the sworn testimony of my victim. So it is actually the police report. And also in this instance, they did a rape kit, right? So it would be the police report and it would be the findings of that kit that would be brought to the judge for the judge to actually grant a DNA warrant.